See, for our polity classes, now we will start with fundamental rights, because fundamental rights, if we have a thorough knowledge of fundamental rights, then we can have a very strong hold on preamble and the previous part 1 and part 2 of the constitution, basically, which will help, which will be a very easy pill to swallow. So we start with part 3 of the constitution, that is the fundamental rights. Okay. Now England, now consider this England. Now if you consider England has an unwritten constitution. So you don't expect England, the constitution, there is no any document or any book where there is some article specified which says that this is the constitution of England. No, England doesn't have any written constitution. It is called as an unwritten constitution. Basically, then you might wonder how this unwritten constitution works. So I will just give you a basic definition of how the differences between written and unwritten constitutions, which will again go back and give it. This we'll cover it in the first chapter. Basically, we'll cover up in later chapters. But okay, basically in England, it is an unwritten constitution. That means all the principles which govern are not written, but they are by conventions. Like for example, king has to sign all the bills passed by the parliament. There is a convention which is there, and there are many charters like Magna Carta, and also many parliament acts like habeas corpus, etc., and many judicial decisions which the judges have given, and many great articles like Introduction to Constitution and Beckhart's. Great authors have written great books which explain the power of a state versus power of the citizens. So all these things constitute the unwritten constitution, the unwritten constitution of England. Now here the person, parliament, so there is nothing as a separate constitutional law which requires a separate process of treatment. So there are no classification of something as a superior law which is a constitutional law and ordinary law. So every law is the same law and every law is made by parliament. So there is nothing as separate status of a constitution in England. So fine. So that is the unwritten constitution. Now if you consider such a case of unwritten constitution as in England, now what do you think? Do you think the individual doesn't have any liberty at all because it is not written anywhere saying that this Article 1, Article 2 or Article 14, Article 15, these are the fundamental rights? So what do you think? In a case like England where it has no written constitution, is there existing a fundamental or individual right? True, there does exist an individual right, but we can say that the individual right in England is secured in a negative sense. That is, now an individual is free to do whatever he wants to do. If he wants to do something, he just goes and does it, unless and until it doesn't violate the ordinary laws of land. If it violates the ordinary laws of land, that individual is caught by the executive and is brought before the judiciary, and the judiciary is the person who gives the decision saying that whether that individual really violated the ordinary law or not. So that is how an individual right is secured. Please understand this. An individual is free to do whatever he wants to do as long as he does not violate the ordinary laws of land. If any suspicion of violation happens, that individual is caught by the executive and he is produced before the court. Now the court will decide whether he actually violated the ordinary law of land or not. So court here protects the individual against executive tyranny. That is, the executive cannot go and punish any individual if there is no law. But here one important point is the court cannot protect the individual from the legislative tyranny. Please understand this. See, a court, now there is some law, say there is some law XYZ. Now a court can protect, a court can make sure that okay, there is this law XYZ and the executive should act according to law. That's what a court can do. But tomorrow, if the legislative, that is legislative is law making organ, that is a parliament. Now if legislative brings out a new law saying that which is a contradiction to this law XYZ, then court will read that law and say that this individual is free. Are you getting the point? Say there was this law A, which according to law A, an individual would be a convict. I mean, he had broken this law and he is liable to punishment. So court will say this individual has broken this law A, so he is liable to punishment. Now, if Parliament passes a law B saying putting some exceptional clause, except in this case, think like that, then the court will read law B and say that this person is free from conviction. So the point you have to understand is, in England, the courts protect against the executive action, but it cannot protect against legislative action. In fact, in England, the legislative, that is a parliament, is considered to be sovereign. There is a statement said that except converting a man to woman, the parliament can do any law. So parliament is not bound by anything at all except the fear of the masses. So if parliament, the concept there would be like, if parliament does something bad, then they will face it by the elections the next year. But that is fine. So the whole concept in England is Parliament is supreme, Parliament is sovereign. So that's the story of, that's how individual rights are there in England, are conceived in England. So please note these 3 points. In England, constitution is unwritten. So it does not mean there is no individual rights. There exist individual rights, but the individual rights is in negative sense. Individual can, that is, what does that mean is, individual can do whatever he wants. If he does something, he will be brought to the court, and court, based on the law, whatever is at present point, it will interpret and tell whether he has actually done something wrong or not. But court cannot protect against a legislative tyranny. That is, the parliament is sovereign and it can do whatever it wants. And in fact, there is no concept of judicial review in England, whereby the court can say that it violates some natural, the law passed by a parliament is violating a natural right, and hence it is unconstitutional. No, the court can never declare any law unconstitutional in England. So this is the condition in England. Now coming to the next extreme, that is United States. Now United States of America. Now in United States of America, it has a very good written constitution. It is federal in characteristic. Now don't worry about what federalism is, because we will have a complete chapter on federalism, and especially where we will study how the status of different things are. So United States is a written constitution, and United States has certain articles called as Bill of Rights. Okay, so here there is a little bit of difference in United States. Now in England we saw that it was parliament supremacy, whereas in US we call it as judicial supremacy. Please write this down, judicial supremacy. So in US we call it as judicial supremacy, and as against in England, where the court protected only against executive, in United States the courts protect the individual rights from both executive and legislative tyranny.